don't know.
Oh, I think you're
But still, it's got different. But there are, what?
So were you getting ready to, or did you go back today?
That's good.
I am.
The Carolina.
Just for retirement, looks like.
Yes.
Yeah, I know. It is. Get him out there.
You know,
I had emergency. I'm no, I don't care. It's fine. Trying to figure out what I'm doing here. Trying to figure out what I'm doing here. What is all that noise?
there we go.
All rise. The Houston County Circuit Court now in session with Honorable Judge David Wolf provided. All those have business will come. God bless.
We didn't be seated. We didn't hear you the first time, right? So we wanted to play it again, so. At the jail, can you hear me? We're gonna have to see if we can get them.
Yeah, we can hear you.
Can you hear me okay?
Yes, sir.
I can't hear you. So, repeat that. Can you hear me?
Yes.
All right. And we're still going on. not sure where they're coming from. So. We'll try this again. 2025 CR 28 State versus Sarah Riley Barnes. Good morning. All right. We have an inmate, I think, in person, Priscilla Ann Brooks. Ms. Brooks, you are here to be arraigned on a charge of violation of probation. It's alleged that you were placed on probation on or about the 14th day of June 2025 for the offense of auto burglary and sentenced to 2 years suspended of probation. It's alleged you have violated your probation by violation of Rule 6, in that you did not have, you left the county without permission or listing your current residence. You have the right to an attorney. Do you wish to have a lawyer represent you? Appoint the public defender to represent you since you are in custody.
Has recently entered the plea in Humphreys County on some charges there, and she's entered into the 23rd Judicial District Drug Court. And I have the documentation here. Spoke with Mr. Beecham the other day, and they're going to be ready to take her into drug court, I believe, Monday,
All right.
if possible. I'm not. Yeah, and on the violation of probation, Judge, he's going to admit to the violation and enter into and complete the 23rd Judicial Drug Court.
All right. Ms. Brooks, raise your right hand. Let's place you under oath. State your full name for the record, please. Ms. Brooks, you are here today charged with violation of your probation. I want to make sure that you understand your rights. You understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation. Yeah. Push that microphone down because it's what I'm looking at is it's right in front of your head. That's fine. You're good. You're good. Apparently we have different dimensions. Is that one working now?
Yeah.
All right. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yeah.
You understand if we had that hearing, you'd have the right to have a lawyer and have one appointed as we've done with the public defender. You understand if we had the hearing and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal. You understand that by entering this plea, you're waiving your right to a hearing and to an appeal. All I'm going to do is approve what your lawyers worked out. You understand that? That means you're going to be actually entering into the 23rd Judicial Drug Court or Recovery Court. You understand that?
Yeah.
You understand that everything I've explained to you?
Yes.
Do you want to waive your right to that hearing by entering a plea according to this agreement?
Yeah.
And I find you guilty of violating your probation, or that you be revoked to serve your sentence. However, you will be allowed to enter into and complete the 23rd Judicial Drug Court program. Now, I have a recovery court entry order that I've been handed that at least purports to bear your signature. Is that your signature on that order?
Yes.
And have you and Mr. Taylor gone over that order? And this order itself states that in open court, it was explained to you that the court doesn't operate, recovery court doesn't operate under the same basis that a regular court, and that you're waiving certain rights set forth in this order to be able to enter into it. You understand that?
Yeah.
I mean, you understand you're basically subjecting yourself to the recovery court and to the recovery court judge's jurisdiction.
Yeah.
As Judge Birch used to say when he started this thing, that they're going to tell you how to live your life from here on out, at least until you finish. You understand everything that order entails?
Yeah.
And I will approve your entry into that program. I'll sign off on the order. Good luck to you. It's a good program. I hope you can stick with it and be successful. All right, 2025 CR 27, State versus David A. Causey. July the 20th for status. All right.
We don't get it resolved.
That's fine. July 20th.
Thank you, Judge. Have a great morning.
Thank you. (2025) CR 4, State versus Melvin Eugene Childers.
He's been trying to set up an evaluation, forensic evaluation, and that he's going through the first part. The second part has been complicated by some medical issues. And the state and I have discussed possibly retiring the case.
Yes, Your Honor. I'm going to retire this case for a year to be dismissed.
Well, Mr. Childers, you're being handed an opportunity to put this behind you due to your medical problems. And what they're going to do is they're going to put your case on what we call the retired docket. It's not being dismissed today. It's being put on hold. And it'll be put on hold for 1 year. If you stay out of trouble for that year's time, don't go out and commit some new offense, don't drive drunk or any of that sort of thing, then at the end of that year, the state's going to come back in and they're going to dismiss it. Now, if you do violate this agreement and you go get arrested on some new charge, then we'll bring this case back on the active docket and we'll start all over again with prosecuting you. You understand that?
Yes, sir.
All right. Are you willing to abide by the law and stay out of trouble for the next year?
Yes, sir.
All right, then we'll retire this case for 1 year. That would be for, what is today, the 22nd? So it probably looks like it's going to be April 21st of 2027. No need for an evaluation if in fact it's going to be retired. Thank you. I understand the agreement is being entered into based on the medical reports that you've already received from these evaluations, and I'll approve that. So, all right, thank you. Let's see. I don't know if we can get Houston County back on. At the jail, can you hear me now?
Yes, sir.
I just can't hear you. See if I can fix that. Hold on.
Yes, sir.
I just can't. All right, let's try again. What is your name?
Stephen Lance.
All right.
Yes, sir.
Just kidding. All right, let's try again. What is your name? We have a loop here, Mr. Lance, so you're gonna hear me repeat myself. But let's deal with it the best we can. I'm not smart enough to fix. We have a loop, so you're gonna hear me repeat myself. Let's deal with it the best we can. I'm not smart enough. You're here to be arraigned on a charge of aggravated assault, domestic aggravated assault. You're here to be arraigned on a charge of aggravated assault, domestic aggravated assault. Do you want to have a lawyer appointed to represent you? Arraigned on a charge of aggravated assault, domestic aggravated assault. Do you want to have a lawyer appointed to represent you? Arraigned on a charge of aggravated assault, domestic aggravated assault. Like it's like deja vu all over again. So I'm sorry, Mr. Lance. Do you want a lawyer? Yes or no?
Yes, sir.
All right, I'm going to appoint the public defender to represent Mr. Lance. Plea about guilty is entered.
I'm through this case is during session. Wanted to represent Mr. Lance because within the last 2 months, I've represented the alleged victim in the case.
All right, I'm going to appoint Crystal Wilkerson to reappoint her to represent this defendant. So. All right. July the 20th for status, and Ms. Wilkerson will be advised of the appointment. Thank you. <clears throat> 2024 CR 31. Oh, let's see, I've skipped over. Going back to page 2 of the docket. 2025 CR 25 State versus William D. Dunlap. Good morning.
Yes, in your honor, we could ask you for one more sad state. That's the medical documentation, but
All right.
I would like to.
You want to set it for status on what day? All right. July 20th. July 20th, Judge Turnbow.
Thank you, Judge. Have a great day.
At the jail, are you Robin Maggie Cox? All right. I'm not going to unmute you because we have a loop going that's going to make a lot of noise, but I'm just advising you that you're here to be arraigned on a violation of probation. Do you want to have a lawyer appointed, yes or no? I'm going to nod your head if you want a lawyer. All right, public defender will be appointed. Need to have plea of not guilty is entered. When do you want to set this, General? It's Robin Maggie Cox, violation of probation. All right, that would be May 26th. Ms. Cox, you've got a lawyer. Your lawyer will be in touch with you. We're going to have a hearing in your case on May 26th in front of Judge Wallace. Thank you. All right. Page 3, State versus Dylan Ray Estes. That is the case that we talked about pre-trial about motions that need to be heard. We'll hear them at the tail of the docket. 2024 Sierra 31, State versus Michael Eugene Odom. I'll put it on the second call. Page 4, 2026 CR 11, State versus Alec Outlaw. Mr. Outlaw, you're to be arraigned on an indictment charging you with aggravated burglary of a habitation, vandalism, criminal trespass, reckless endangerment, and assault. You have the right to an attorney. Do you wish to have a lawyer? Are you planning to hire your own lawyer? Right. You want me to read this to you in open court, or do you want to read it yourself? All right, so he's waived the full reading of the indictment. We'll enter a plea of not guilty, and I need to set it for status. Whose case is? All right. All right, I'm giving you 2 dates, and I've written them both at the top of the indictment. The attorney status means that you come back in and let the judge know whether or not you've been able to hire a lawyer or not. That's going to be on May the 26th. As far as the status, as far as whether to get your case ready for trial, that's going to be in July, on July the 20th. So the first thing you need to worry about is getting your lawyer and getting that lawyer in court on that May date. Okay. All right. Thank you. (2021) Sierra 38, State versus Robert Lance Parker. Parker, you have pro se motion that you have filed that sets forth that you're asking that all probation fees in this case be waived, that your probation be terminated based on issues not being allowed to travel outside the state as your job requires you to do, and to allow you to go ahead and have an expungement of your case. You understand that this was entered by this court. I think the judgment was entered in June 26th of 2026. I'm sorry, June of 26th of 2023. Therefore, for a 2-year sentence, therefore the expiration of your sentence would be June 26th of 2026. You understand that?
Yes.
All right, and you're asking, and you're not eligible by statute to have your record expunged until such time as the sentence is expired. You've completed your sentence, because if I grant you an expungement, which I don't think I can legally do, while you still have 2 months or so of your sentence to complete, then let's say you violate that by committing a new offense, then basically I've violated the law by expunging a sentence that's still pending. So I'm not going to grant your request to expunge your sentence early, nor am I going to require I'm not going to grant your request to terminate your probation, because you are still on probation. And under the circumstances of this case, I don't find it appropriate to grant your request to terminate your probation. I think your probation officers can work with you about your work schedule. As far as your fees, your probation fees that you're asking to waive, if you want to file an affidavit with the court of your income and expenses, that would let me know.
Yes, I just mess up because of time out of institution that I had to pay, that for the money that I'm still paying. And, I know that a sentence is supposed to expire in June. And, I was wanting to try to get those, waived so that I wouldn't have to worry about that at that time. Trying to come up with all of that to pay that as well.
Well, let's see what the situation, let's put it on June 22nd. That's in front of Judge Lockhart Mash, and let her decide whether or not to grant your request. I don't have a problem with, once your sentence is about to expire, determining whether or not you need the relief from that, but I'll let her take care of that. We'll see whether or not what your situation is in June.
Okay, but that's gonna be past the expiration date, and I'm just worried it's gonna.
Your expiration-
violate or to stop my time.
Well, how much do you owe? This would be the next one of us. If you even know. Have you paid all of the restitution?
Yes, sir.
That was $14,713.
I think it was around 15.
I'm sorry, yes. 15,322.49 is what your motion says. State have any opposition to Mr. Parker having his probation fees for the remainder of his probation terminated? I'll grant that request, and the probation fees will be remitted.
And another question with Rick Judge is, can I go on unsupervised probation?
What's the state's position regarding requests for the last 2 months to be on unsupervised probation? Who's your probation? All right, I'll agree to allow him to be on unsupervised probation for the remaining 2 months. So. Well,
Sir,
Thank you.
and my probation pays for what today.
yes.
Thank you, sir.
2025 CR3 State versus Dewey Preston Robinson. Mr. Blake's his attorney.
The Court of Companion case, with Mr. Robinson in Stewart County, we set it for trial in August. And that's all we were gonna do today. If you want a second call it, I can go call Mr. Roy and see what the
Okay.
ETA is.
I'll put it on a second call if we want to check with him about a trial date. Thank you. 2026 CR10 State versus Christopher Kane Shelton. Pratt. All right. Waiver of arraignment shows that Mr. Spratt is the attorney of record. The plea of not guilty is entered. Show he's been arraigned. Trial status. July 20th for status. Thank you. 2025 CR33 State versus Sean Tidrow. The short.
I thought that we would have a line.
All right. You want to tender that to the. All right, Mr. Tidrow, raise your right hand. Let's push you under oath.
Yes.
State your full name for the record. You can put your hand down.
Sean,
Mr. Tidrow, you're here today charged with the offense of driving under the influence of an intoxicant first offense. Have you seen or been shown a copy of that charge, talked it over with your lawyer, you and Ms. York, discuss the range of punishment you're facing as well as any possible defenses you might have? Well, it's indicated that you want to enter a plea of guilty to the charge according to this agreement and receive the minimum sentence. Have you seen or been shown a copy of that charge and talked it over with your lawyer and discussed with her the range of punishment you're facing as well as any possible defenses you might have?
yes, sir.
She wants you to sign off on that plea sheet form. All right. All right, let me start over again. Do you understand what you're charged with, and do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury? You understand that you would have the right to have a lawyer and have one appointed if you cannot afford your own. You understand at trial you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors. The verdict will have to be unanimous before you can be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and Ms. York could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena. You understand that if you went to trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that if you enter this plea, you are waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out, and that is to give you the minimum sentence the law provides.
Yes, I
Do you understand that's going to result in a conviction? That conviction is going to be on your record in the future to make more severe the punishment you'll receive if you are ever again convicted of a crime.
Yes.
I've been handed what we call a notice of DUI enhancement. Have you seen that before?
Yes.
Have you read through this form and gone over it with Ms. York so that you fully understand that every conviction on your record carries for the next time a more severe punishment? And it continues to escalate if you're ever again convicted of a crime. You understand that? And I'm going to have you sign one of these forms, hand the other one back in two of them. You keep one, sign one of the forms and keep the other one. The one that you sign, I need to turn to this. Ms. York, this order for restricted driver's license, you and he will need to fill this out and fill in the requisite information and then submit it to me after it's filled out completely. Okay? Let's have Ms. York sign for that X is. All right. Do you understand if you plead guilty on this case, the court of the state could ask you questions about the offense, and if you answer the questions under oath on the record, and I think you're pleading no contest, is that correct? Then if you're pleading no contest, then is your decision to plead no contest voluntary?
Yes.
Do you understand that simply means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be? You understand that? You understand I cannot accept your plea unless I'm determined it's voluntary. Anybody forcing you to do this against your will? You understand I can't accept it unless there's a factual basis for it and that I found that you are in fact guilty. You understand that?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial.
Highway 129, sorry, heading towards Cincinnati, and crossing it was dispatched as a reckless driver. Sergeant was got behind the driver, kid, the driver was off the roadway, he made a stop, asking if he consumed alcohol. The driver didn't have about 2 drinks, they performed a sobriety test, he performed poorly. Sergeant Booth asked the defendant to take a blood alcohol test, he consented, and that did come back to 0.1.
I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be if you went to trial.
Yes, sir.
You still wish to plead no contest according to this agreement. Are you satisfied with your attorney's services? You feel like Ms. York has done a good job of representing you confidently?
Yes.
Sure, do you know of any reason you should not enter this plea? Then Sean Tidrow in docket number 2025 CR 33, upon your plea of no contest to count 1, I find you guilty, sentence you to 11 months and 29 days in the county jail, and will be suspended to supervised probation after you've served a mandatory of 48 hours with credit for time served. You must have an interlock device installed and restricted license during your probation period. The statutory 48-hour incarceration period will be completed at the DUI center, and he must report within the next 30 days to begin serving that sentence. He's ordered to pay a $350 fine in court. That's the judgment report. He'll need to see the probation department. 2025 CR 36, State versus Patricia Jane White. Right.
One is charged with introduction of contraband into the Tennessee, and the state has agreed to amend that to simple possession. Been pleading guilty to simple possession of scheduled.
Yeah, no contest, is that,
Or, yeah,
Okay.
no comment.
I want to make clear. All right, and it'll be simple possession, 1129, suspended probation, $750 fine and cost, and she has to complete alcohol and drug assessment and follow the treatment recommendation. Ms. White, raise your right hand, let's place you under oath. State your full name for the record. Ms. White, you are here today charged with introduction of contraband into a penal facility, which is a felony. It's been agreed that you would plead to an amended charge of simple possession. But have you seen or been shown a copy of the charges so that you fully understand what you're charged with and any possible defenses you might have? While it's indicated you want to enter a plea of no contest or nolo contendere, that just simply means, as you've heard me say, you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they present it to me. And that evidence will be used by me to find you guilty according to this agreement. You understand that? You understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury in this court. You understand if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own, which of course I've done with a public defender. Speak up just a little bit because we are recording all of this, okay? You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and Mr. Taylor could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by using a subpoena. You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea, you're waiving your right to the trial and to the appeal. All I'm going to do is approve what your lawyers worked out. You understand that? You understand that's going to result in a misdemeanor conviction, and that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You understand everything I've explained too? Do you want to waive your right to a trial and to an appeal by entering this plea of no contest? Is your decision to plead no contest today voluntary? Anybody forcing you to do this against your will? You understand I can't accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty. And I want you to listen as the state tells me what their evidence would be if you went to trial.
That Miss White was picked up for an FTA warrant in Houston County, and she was being booked in. She was searched by the jail. She had methamphetamine in her honor, and I'm sorry, that would have been on November 2nd. Yes, sir.
I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be if you went to trial. You still wish to plead no contest. Are you satisfied with your attorney's services? Feel like Mr. Taylor's done a good job of representing you competently. Mr. Taylor, do you know of any reason she should not enter this case? Anything further from the state? Patricia White and docket number 2025 CR 36 upon the plea of no contest to count one an amended charge of simple possession. I find you guilty, sentence you to 11 months and 29 days in the county jail. You're ordered to pay a $750 fine and cost. As a condition of your probation, you must enter and complete an alcohol and drug assessment and follow any treatment recommendations. Thank you to the probation department. Let's see. 2025 CR 35 State versus David S. Wood. Good morning.
I had filed a motion, I'd like to strike that.
That motion is stricken. And, well, where are we then on the case?
Ready, set for trial.
All right, we're gonna set it for trial. General, you have is this a case that I need to hear, or you got?
August, we'll put it in front of your honor in August if that works better for Mr. Meeks. 25th, 26th, or 27th. One day.
Well, the 25th, we have the Cook Dasher case. It's an attempted first-degree murder. And that's expected to last several days, but I would suggest you put it on the 27th,
Okay,
August 27th for trial.
thank you.
Thank you, Jeff.
Right. Go back to, you go back to State versus Sarah Riley Barnes. Did we, already take care of that? I have the violation of probation warrant up here. Were you appointed to represent Ms. Barnes? Philip, Philip. We also have, Stewart County case that I think we had brought over. Stanford, I think, you were not able to be in court the other day, and this is a matter of, my understanding is that Josiah Terrence Nixon, and it's a motion for a furlough for an evaluation at a psychiatric facility.
Yes. That would be Trust Point. They lock down the facility. You go there for an evaluation if they determine he needs treatment, he be treated. Once he was treated, that's 5 to 12 days, depending on what they say is needed. Then he would be returned to jail. He would never be out walking the street. Been jailed for 6 months. I understand the state position may be no, he's druggy. Whatever drug he's on if he was, he's had 6 months detox, but he's still having some behavior that suggests something's not right. He does intend to leave jail when he does and go to a long-term facility. That's my issue. I'm not.
So he's had a furlough from the General Sessions Court of Montgomery County to go into a psychiatric facility. And Judge Andy Brigham of Stewart County General Sessions Court has also signed an order for a furlough to a psychiatric facility for an evaluation. How is this any different than us ordering that he be evaluated for competency? This is, you're asking for treatment rather than evaluation.
Asking for evaluation, treatment if they determine it's needed, then return to jail. So it's a little more than a competency determination.
And this facility that, I don't know that I have a copy of the order from the other courts. Do we have a copy of that order?
I didn't see that. Nope. Please. I have not voted.
Well, let's step aside and let Mr. Woodall have his side.
The state, places estimation of furlough. I don't know anything about this place. But no proof from any representative from this place to come in here and tell the court what the procedure is, how long they stay there. So I don't know. Mr. Nixon is currently got a BOP for a 3-year sentence, which 3/11/29 running consecutive that he pled to, that he's violated because of a new DUI he got, which is still pending in general sessions court. And has been bound over because of these issues.
Well, do you disagree that Judge Brigham has granted the furlough to psychiatric facility, to this facility?
We're asking for an evaluation, sir.
Well, hold on a second. Raise your right hand. You solemnly swear or affirm the testimony you're about to give in this case to be the truth and nothing but the truth, so help you God. You are Ethan Gray. You are the General Sessions and Circuit Court Clerk in Stewart County, correct? And you're here today because this is a Stewart County case and we brought you in all the way over here so that you can be heard. Actually, not be heard, but you can bring the file. And as a part of your duties, are you in General Sessions Court on a regular basis? And do you have familiarity with Mr. Nixon's case? And were you aware that Judge Brigham has or has not signed an order granting a psychiatric furlough to a psychiatric facility? Are you able to have your office transmit a copy of that order to the Circuit Court Clerk's office here this morning for me to review? We'll pass this case until I can get that. In the meantime, Mr. Stanford, it might be helpful for the state to be advised as to what, if you're able to show them any kind of information. I understand there's something called Google search that you can go online and pull up. Yeah, you can pull up some information about the facility so that it will be given to the state so that they can make a determination of what kind of facility it is. All right. Or second calls on anything. Yeah, thank you. We'll have you step back, Mr. Nixon, until we're ready for you again. Anybody got anything else that we can take up before we break? Take a mid-morning break. All right, I'm going to take a short recess and then we'll come back, take up any second calls, and then I'll hear these motions that need to be heard in the other case.
Yeah, so. Yeah. 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 Without the power. Yeah. Yeah. Mario. Robert. Yeah. Oh, yeah. Yeah. You know what's the trailer? Yeah. Oh, yeah. 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 Master Nation. Really. Robert. That he successfully completed probation with no violations. Just did everything he did, no failed drug screens, reported every time, like, has he ever done that? Ever. Has he ever done that?
And of all these 80 cycles.
Ever successfully completed, ever. Yeah.
He has a small case.
This,
He tried it, but. It's like not accurate.
I say, I don't know. I had to come across them. I'm positive. August. Are you your supervisor? No. Yeah. Hey, say some folks.
I'm just making sure everybody.
That's the sex story.
I just got off the phone with them and they got on there. Reason.
July 1st.
Well, thank you again.
I double check you yesterday. Yeah. I don't see how this is going. Well, so where's the alarm? You know the date of this one? 1:30. Yeah. Well, no. How do you know this is right? Where do you get this? This note was 100. Well, I have 100 dollars. About what? How do you know that? What about this one? Good, you on chat, that's good. Video still? Yep. Yeah, because clients actually insulted them. Okay. Can we count one? Yeah. Didn't have to prove anything. She can set that it counts. It's just PTSD. What is this thing? Ah. Go to my phone. Oh, what? I don't understand, like, yeah.
Right.
Yeah. Calling her mom.
Thank you, everybody. Yeah, you probably see. Yeah, good. Amazon. Yeah. The sour yesterday. I don't know.
Contacted the agency. Lisa Angel. Lisa Angel. You want me to send you her contact? Yes.
Yeah, you get special.
What?
You get special retirement like the prize job.
The bill now. I didn't hear it. My alarm, I just hit start. I think it's better. I think I'm do something. That's like playing, you know?
Yeah.
I don't mind doing that. Yeah, really, if I had my hair styled at that time. Right, Lisa.
Oh.
All right.
Okay.
Well, yeah, we'll just.
All right. Look back in the paper.
All right, is there anything we need to take up before we begin the hearing on the Estes case? What about Mr. Nixon's situation? We get any information about that?
I haven't seen either Mr. Gray or Mr. Ack.
Snooze, you lose, so we're gonna take up your motions on. Okay.
And she filled out the affidavit of indigency and turned it into the clerk's office and thought she was supposed to leave and left. So I don't know where that affidavit is, but I suspect I will get appointed.
I have thrown away my copy of the docket or something, I'm not sure what. You have an extra copy of the document. All right. This is, who was this again? Sarah Barnes. Do we have her affidavit? All right, Ms. Barnes says she has no income. She has a bond, correct? All right. I'm gonna appoint your office to represent her. I'll give you an opportunity to try to contact her. Do you wish a formal reading of the affidavit? And we'll appoint you in a plea of not guilty. We'll set it for that date in June, or is it May? May the 26th. And the only thing I would say is that she's left, so you're gonna have to contact her so that she can give you all the requisite information that you need. So, we don't have, Mr. Gray, have you been able to locate anything? Okay, I'm about to start a motion hearing in the case. I just was trying to get anybody else, anything else that they have before we start that motion hearing.
I know all we were doing today was setting it for trial. Mr. White said he was in Montgomery County, he can come over when he got done, but that's all we were gonna do, we set it for trial.
Well, let's pick a date.
Do it for 8/27, we'll do the DUI that we just set.
8/27
Yes, sir.
for trial. I expect this motion hearing to be real lengthy, so Mr. Gray, when you get that copy, would you just have it, Mr. Tomlinson, if you'll hand it to my bailiff, then he'll hand it to me. And give a copy to Mr. Woodall so that everybody's on the same page, and we'll go from there. And then any information, Mr. Stanford, that you found out about this facility, you can share. All right, well, I'm gonna take this motion hearing up and, because it involves a case that is set for trial tomorrow, is that correct, Mr. Estes? And it involves an aggravated sexual battery. I'm going to terminate the